Hello everyone. Recently there is a news where 90 years of imprisonment is imposed upon a school headmaster of Sundargarh. The sentence is passed by a special POCSO court while considering the matter before it. The school headmaster is charged for the special POCSO offences along with section 354 or other IPC offences. Apart from that, he is also imposed with a fine of 47,000, in default of which there will be another 6 months of punishment. Again, the provision relating to default of fine is given under section 30 of CrPC. That is not the prime matter of this video, but will somehow exhaustively cover the dilemma or the anomaly present under section 31 of CrPC. Some media houses or other, it is being portrayed in the news like that the convict has to undergo a total of 90 years in the prison. But this is actually not the case. The convict actually has to undergo an imprisonment of years, the duration of 10 years only, due to the concurrent running of the punishment concept present under section 31 of CrPC. There are actually two modes of this punishment execution, imprisonment of punishment execution, namely the concurrent one, and another one is the consecutive one. Where concurrently means जोठी आपन को मनकर 10टा ऑफेंस पे 10 प्रकार पनिशमेंट मिलिथो. For offense number 1 there may be 2 years. For offense number 2 suppose there may be 3 years. For offense number 3 there may be 5 years of imprisonment. Like this, for each charge there will be specific punishments. In the judgment it will be written that whether the nature of the punishment would be of concurrent nature or would be of consecutive nature. If it is prescribed as concurrent in nature, then simultaneously the convict has to undergo the entire duration of the imprisonment for the maximum prescribed punishment. Suppose for गोटे ऑफेंस पे मनकर अच्छी 5 वर्ष पनिशमेंट, सेकेंड ऑफेंस पे अच्छी 3 वर्ष पनिशमेंट. यदि कनकरेंटली मेंशन होती ताले मैक्सिमम से 5 वर्ष ही प्रिजन में रहिबो, आउ जो 3 वर्षर पनिशमेंट ऑफेंस नंबर 2 पे अच्छी से 5 वर्ष भितर ही सेटा कवर हो. व्हेयर एज इन कंजिक्यूटिवली सेंटेंस, कंजिक्यूटिव सेंटेंस रे कोन हबो ना फास्ट से 5 वर्ष रहबो ऑफेंस नंबर 1 पे, तापरे ऑफेंस नंबर 2 पे 3 वर्षर 3 इयर्स पनिशमेंट से सर्व करिबो प्रिजन रे. So this is the concept of consecutive and concurrent punishment impounded under section 31 of CrPC. Actually this is not the dilemma. The actual dilemma lies in section 31 subsection 2. It suggests that in a case of consecutive sentences, it shall not be necessary for the court by reason only of aggregate punishment for the several offences being in excess of the punishment which it is competent to inflict on conviction of a single offence to send the offender for trial before a higher court. So there is no such dilemma here, but the actual dilemma lies in the proviso part. Provided that in no case shall such person be sentenced to imprisonment for a longer period than 14 years. The first proviso mandates that for consecutive sentences, the maximum limit set, the yardstick is 14 years. In no case the limit or the quantum of punishment for consecutive sentence would exceed 14 years. Whereas proviso B mandates that the aggregate punishment shall not exceed twice the amount of punishment which the court is competent to inflict for a single offence. But here actually the controversy is particularly for section 31 subsection 2 proviso A. Proviso A, it is mandated that imprisonment should be should not, actually imprisonment should not exceed 14 years. Here in this case actually এটা দেখা যাଉଛି যে এটা 90 years punishment ବୋଲି ସବୁ media houses କିମ୍ବା news ରେ ଆପଣଙ୍କୁ ଦେଖା ଯାଉଛି ଏଟା 90 years punishment is imposed upon the accused or the convict, but actually it is of 10 years because the sentence ର nature ଟା ହିଁ concurrent nature ଏଟା ଲେଖା ହେଇଛି ଏଟା concurrently ହିଁ run କରିବ, so ଏଟା maximum ସେ 10 ବର୍ଷ ହିଁ ଜେଲ୍ ରେ ସର୍ଭ କରିବ, ନାହିଁ କି 90 years. But the other part of the coin is that jodi 14 years limit in a landmark judgment, whether a court of session, the question is that whether a court of session while granting a consecutive sentence exceed the 14 years cap or not. गोटे कोर्ट ऑफ सेशन ने जदि गोटे ट्रायल चली तो से कोर्ट ऑफ सेशन पावर अच्छी कि गोटे कंजिक्यूटिव सेंटेंस 14 years रु अधिका पनिशमेंट दवापाई यही केस को जब कनसीडर करवा, सपोज एटा कंजिक्यूटिवली दे था कोर्ट चाहूँगी ये कंजिक्यूटिवली देवे 90 years पनिशमेंट अच्छी आम 90 years कंजिक्यूटिवली हम ऑफेंस नंबर 1 by 10 years, ऑफेंस नंबर 2 by 10 years, सपोज देयर आर 9 such categories of offenses for which 10 for each offenses there will be 10 years of punishment. 10 वर्षर जी 90 years of punishment, 90 years of imprisonment will be of consecutive nature. एमती किसी जजमेंट हो पारि था कि by imposing in contravening section 31 subsection 2. While answering to this question, the Honorable Supreme Court has made this point clear, and it is a settled principle that the section 31 subsection 2 is not applicable to court of sessions. The relevant citation is AIR 2016 Supreme Court 3340. Now you will tell me the answer or the name of the case in the comment section below, in the comments below. But this is a homework for you and probably the task for you to find out the necessary the case title of the citation. Let me repeat it again, AIR 2016 Supreme Court 3340, where it was held that section 31 subsection 2 is not applicable to court of sessions. Actually there is a misconception which is quite prevalent among the in the legal fraternity, that they think that section 31 subsection 2 probably also applicable to court of sessions. Actually this is not the case. It is a settled principle that section 31 subsection 2 is not applicable to court of sessions. And furthermore there is a case of 2005 Supreme Court where it was also held that the word imprisonment present under section 31 means and includes the life imprisonment. The citation is AIR 2005 Supreme Court 2132. Again this is also again a homework for you to find the relevant case title for this citation. You can mention the case title in the comments below, where it is mentioned that the term imprisonment in section 31 CrPC would also include the sentence of imprisonment for life. And section 31 subsection 2 is not applicable to court of sessions. So court of session while passing a consecutive sentence can also exceed that 14 years limit, because originally inherently the court of sessions has no such limits. Court of session has unlimited powers, provided for death sentence the approval of High Court is required. That is the only limitation imposed on court of session. Otherwise the court of session has unlimited power. This is only for the magistrate courts or other than courts of court of session. So that's all for today, and I'm hopeful that you will be able to find out the necessary case title for the given citation. This is a locus classicus in this regard, so this is worth the struggle, I can say that. So until then have a very good day. Thank you.